So, Mitch, I think it's important. Many of us are on this call and in this industry have been through a number of key document changes. The many 1003 evolutions that we've been through over the last 10 years have occurred that have impacted business. And so when you look at these new disclosures and the way that they're laid out and the information that they present, what are your candid thoughts? Have they gotten it right this time, and what new challenges have been created?
Well, this is the biggest change this industry has actually ever seen. This reflects a huge paradigm shift that I actually think has a larger impact on the industry in terms of costs, changes to systems, processes, training that's necessary. It has a larger impact than even those 7 combined rules that became effective in January. So this is a very, very big change, and one that's going to take a whole lot of training and process changes to get it right. And the integrated disclosure rule replaces the good faith estimate and the initial truth in lending with the loan estimate form, and it replaces the HUD-1 and the final TIL with the closing disclosure. That in and of itself is a big change, but beyond the fact that you have to deal with different forms, there's really a change in philosophy over here. The philosophy in the past was to disclose fees in a bundled manner, and that's how you did it on the GFE and the HUD-1 settlement statement. Now it's going to be an itemization of fees and charges on the loan estimate and the closing disclosure. Very, very different. Disclosures actually are going to look different transaction to transaction, which creates quite a bit of a technology challenge itself. And that's because you're no longer going to have these numbers or groups. Rather, you're going to list the fees and the charges alphabetically. So this is, in fact, a very, very big change. And it's going to impact closing as well, because under the new rule for integrated disclosures, which will kick in on August 1st of 2015, there's a waiting period before closing, and those integrated disclosures need to go to the consumer, need to go to the borrower at least 3 business days before consummation, before closing itself. And that in and of itself is going to create some technical issues that the industry has not really seen in the past. So as I said, it's big. Creditors are responsible for the disclosures themselves, even though they have to rely heavily on the settlement agents. So that's a change as well. They're going to have to integrate the lender's process with the closing agent's process. And then there are new thresholds. I mean, you're essentially guaranteeing the fees if an affiliate settlement service provider is used for anything. You only have a 10% aggregate tolerance if, in fact, it's a required charge and they pick someone off of a list that you gave them of providers themselves. So it's a big rule that a lot of people don't fully understand today. I mean, the reality is the GFE form that we are utilizing today became effective in 2010, and we're still getting a lot of questions about how to fill out that particular form. So you can only imagine how many questions we're going to get about the new integrated mortgage disclosures. And it's going to be a process that's going to evolve over time as loan officers get more used to it, as their companies and compliance get used to it. It's going to be quite a learning experience.